All right, Mr. Johnson is plaintiff. Mr. Walters is plaintiff. And Ms. Lambert, you're plaintiff also.
Yes, sir.
And I see Ms. Jones is here. She is the plaintiff. I see Craig Knox is counsel for, is it all defendants or less than all the defendants, Mr. Knox?
It's all the defendants in this lawsuit. Hang on a second.
Knox, you might have to turn a cell phone off or something because that's not going to work for me.
Yeah. I don't have a cell phone, Judge.
There's some other phone, some other instrument giving interference. You sound like that show on that British space show on PBS, Doctor Who. Is that right?
That's right. Is this better?
That's much better. So you're all the defendants in the suit are relevant to the motion or what?
I'm representing two of the defendants in the lawsuit, but for the purposes of this motion, I'm representing Rick Swearingen in his official capacity as the Commissioner of the Florida Department of Law Enforcement.
Okay, so you represent Swearingen in official capacity, and do you represent defendant Pratt's or there's a Doe defendant? Do you represent Pratt's also?
I do represent Mr. Pratt, but he's not really a party to this motion today.
I understand. So we have lawyers for everyone here. I believe that the press is here, so obviously the press is welcome. So if y'all have any problems, if the press has any problems hearing something, if you would just call my judicial assistant, I'll ask her to get a message into me, and if I can fix it where you can hear or see, I will. But you've already witnessed the limit of my technical skills already. But I'll tell my judicial assistant if she gets any calls from the press about being able to hear or see, let me know, and I'll do what I can do. Hold on a second. Sure. I said if the press people want to hear, call you, let me know. I don't know if you probably won't get it. Let you know if they do call. Yeah, well, they get the stuff. Right. Hold on, one more thing I've got to check on. The other people are calling at 3:30. Okay. All right. I've also expanded the time available for the hearing. After reading the memos, I got concerned that 30 minutes might not be enough time. So I have another hearing which I've extended until 3:30, so we can go until 3:30, and then I've rescheduled that hearing until later time to give us more time on this. You're not required to take up all the time, but if you feel like you need more time, I'd be glad to divide it 50-50. So we'll start with the plaintiff. I've read everything a couple times for each party, and I've looked at your research and I've done some of my own. So who from the plaintiff would like to start the leadoff argument?
I will, Your Honor.
Okay.
Thank you, Your Honor. We're here on a motion to return the property of Rebekah Jones that was seized by FDLE in an unlawful search on December 7th, 2020. The motion is supported by a verified complaint. At the threshold, FDLE has raised a jurisdictional issue, which is one that we carefully considered way back before we filed the complaint. and we rejected that jurisdictional concern. They say we must seek return of Miss Jones' property in Judge Hawks' case. But Judge Hawks has no case.
But I'm going to save you some time, Mr. Johnson, unless Mr. Knox has an argument on that is not in his memo. Here's what I think about that argument. Just give me a second. You should have asked me, you should have brought this up yesterday when I could find my copies of my cases, but there's two cases in Florida, one a Florida Supreme Court case and one a district court case that discusses this. Let's see if I can locate it for you. Hold on a minute. All right, the Supreme Court case is Harvey versus Drake. It's 40 Southern 2nd 214, Florida Supreme Court 1949. And I would refer the parties, if they want to read it in detail, to page 218 till the end of the opinion.
Join the meeting.
Also, I would refer to you to Sawyer versus Gable, which is 400 Southern 2nd 992. And keynote 3, and I'll quote to you the operative language that seems to me to be relevant on this issue in that case. Quote, "It is clear under Harvey v. Drake that any circuit judge would have jurisdiction under section 933.14 to entertain a motion to return the property," end quote. Based on that, and having read everything else, and if Mr. Knox wishes to further argue it, I will hear him, and Mr. Johnson, I'll give you time to rebut it. I just don't think at this point that that's the best use of your time, because I just, right now, unless I hear something different from Mr. Knox, I believe I do have jurisdiction. Well, let's put it this way. You're not required to go to Judge Hawks. I'm a circuit judge, civil circuit judge in Leon County, and I drew the straw from the clerk as to who got this case, and therefore, as I read these cases, I have jurisdiction. It's not an indication of my ruling one or the other, but you're in the right place, at least for now. If a criminal case had been filed, I think the right place would then shift to that criminal case, but as far as I know, there is no criminal filing at this point.
Yes, Your Honor, that's right.
I'm not telling Mr. Knox he can't make that argument, but I can tell you based on what I've read, I'm not there on that point. So I want to save you the time so you don't have to argue it, unless you just want to.
No, I don't want to. I would rather go on to the merits.
Okay.
If we're not going to fight about jurisdiction, then that's great.
We'll see whether that's great or not, but at least it's the first hurdle you have to get by, and you've cleared that hurdle in my mind.
Yes, okay. So on the merits, we're looking at two main lines of argument for the return of the property. And I think the first and the strongest is that the search warrant was void ab initio. And the reason is that there is not even theoretically a crime that has been committed. And if there's not a crime that's been committed, there is no basis for a search and seizure of anybody's property. And I offer 4 reasons why there was never a crime committed. Under the statute 933.14, in order to commit the crime of unauthorized access, the access has to be willfully, knowingly, and without authorization, has to be performed. in
Hold
that
on a
way.
second. I just want to grab my copy of the statute.
Okay,
I have it here. Just a second, and I'll have it. Okay. 815.062, right?
no, 933.14.
Oh, 933.14. Well, I have that also.
Okay.
Okay.
All right, let me
So-
read the pertinent part. It says, a person commits an offense against users of computers, computer systems, computer networks, or electronic devices if he or she willfully, knowingly, and without authorization or exceeding authorization, A, accesses or causes to be accessed any computer, computer system, computer network, or electronic device with knowledge that such access is unauthorized or the manner of use exceeds authorization. So
Okay.
we've got,
Excuse me,
big
but for
cons-
the record, you're reading Florida statutes 815.06 2A.
oh,
You're not
Pardon
reading
me.
from 933. I think we're on the same page. I think what you want to argue is whether this statute applies. There's probable cause for violation of this statute.
yes.
Okay, I'm with you.
All right. So there's 2 big things about this statute. One is that it must be willfully, knowingly, and without authorization accessed. And second, the knowledge, with knowledge that the access is unauthorized or that the manner of use exceeds authorization. Now, let me just say a couple things about that. Let me say 4 things about that, okay? The first thing is that the user ID and the password for the website or the message board that somebody, not Miss Jones, but some person somewhere sent a message to was on the DOH website in 7 different places.
So, Mr. Johnson, let me give you a hypothetical and ask you this question.
Sure.
If you left your car in your driveway with the doors unlocked and the keys in the ignition, would it still be illegal for somebody to come in without your permission and take it and drive it off for a weekend?
Yes, it would.
Okay,
However,
isn't that what we have here?
no. What if I put a sign on my car that said, keys are in the car, take a spin?
Okay, are those the facts in this case?
Well, those are the facts in this case in that they put the username and the password out there in 7 places. And they didn't put it out there to be ignored. They put it out there for somebody to read it. And they didn't put it out there for somebody to read it for their amusement. They put it out there for somebody to read it for their use.
Or they were negligent?
Well, all right.
Just like if you left your car in the driveway unlocked with the keys in the ignition, that doesn't authorize you to have somebody to take your car without your permission.
Well, if I'm telling the world that my keys are in the ignition, would somebody be remiss in inferring from my giving that information that I was forbidding use? No. If I'm saying, hey, my keys are in the ignition, but I'm not saying, please use it, it's enough that I'm saying the keys are in the ignition, isn't it? Why would I be giving that information?
I just don't think that would be a defense it might be a good argument to a jury, don't get me wrong, but I just don't think that would be a defense to the charge of stealing your car. Say, well, Mr. Johnson left his keys in his ignition, so therefore, from that, I concluded I had the authority to take his car without asking him.
No, you're leaving out the key element, though.
Which is?
I'm saying the keys are in the ignition, and I'm informing the world that the keys are in the ignition. I'm not informing the world. I'm not saying, please come and take my car. I don't need to go that far. All the farther that I need to go is to say, hey, my keys are in the ignition, because I'm saying that for some reason. I'm not saying that for anybody's idle knowledge.
So if you go up to the drive up the side of the road, there's a vegetable stand where people sell vegetables, and they operate under the honor system. And they say, this is the honor system. Here's the cash box. You take a dozen tomatoes, that's $4.50. Pay $4.50. If you need to make change, here's the money to make change. Does that authorize somebody just to take the tomatoes and not pay for them?
Well,
Since
no.
there's money there? Or does it
Yeah, I mean,
authorize them to take money out of the cash box? It's there, it's on the honor system. I'm not just making these up. This actually happens locally in our area with vegetable stands. And believe it or not, some people still leave their keys in their car in their driveway.
Well, yeah, but I mean, I don't know why you keep omitting that I'm announcing to the world that my keys are in the car.
Okay, so help me, where was that announced in this case? And that would help me.
They're saying, here's the username and the password.
Where is that? Is that said online?
7 places online,
Okay.
7 places. And, you know, you don't be, if I tell you my key's under the mat, am I just telling you that so you'll know? Or am I telling you that so you can reach under the mat if you want to use the key?
Here's the problem, Mr. Johnson. I just don't think that's an issue that I can decide at a motion stage. I think that at best is a jury argument. I don't think I can make that call. The test is what is said in the statute, and are there allegations in the probable cause which support the elements of that statute, isn't it?
No, yeah, I mean,
Not
look,
the test for probable cause?
no, if that were the case,
Well, what is the test for probable cause?
the test for probable cause would be that if there was some kind of a warning saying, don't come in here, or this is users only, or when you go in, something comes up. I do that all the time. I do that on Westlaw. Westlaw flashes a big thing and says you're going outside what you paid for. You can't come in here unless you pay more money. And so I back out and use as much as I'm authorized for. But if they don't warn me, they're not going to be able to charge me. And so there
Mr.
has to
Johnson,
be
let's look
some
at the
kind of
statute.
what?
Let's look at the statute. 815.06(2)A says a person commits an offense if they use a computer system or a computer network, if they do it willfully, knowingly, and without authorization or exceeding authorization, and they access and use that system. Those are the elements, right?
Right.
Well, let's look at the search warrant affidavit. That's attached to your information here. Here's what I've got, what I see on page 3. He says there was a system called the ESF8 system on the ReadyOp platform, and that's called the Florida Emergency Support Function for Public Health and Medical System, that's used by the state's health and medical resources. It says the group state ESF8 system is utilized by multiple users, some of whom are not employees of the Florida Department of Health, but are employees of other government agencies. It says once they are no longer associated with ESF8, they are no longer authorized to access the multi-user group. And then they allege that Ms. Jones is a former employee of FDOH and is no longer authorized to access it. Doesn't that meet the elements of the statute?
No, that's an Ipsy Dixit. Where on God's green earth did Mr. Pratt's get the knowledge of who's authorized to use it? If somebody's not authorized to use it, the Department of Health has a policy or a procedure manual. It has some kind of writing somewhere that says this is confidential. He didn't cite anything like that. He doesn't work at the Department of Health. He has no knowledge. And if anybody told him that, it's hearsay and it's not admissible into that affidavit in the first place.
Are you saying that Ms. Jones actually had the authority to use that network?
I'm saying anybody in the world had the authority to use that network. I'm saying anybody in the world had the authority to use that network. Anybody in the world, because there's nothing anywhere that tells you you're not authorized. There's no policy of DOH that makes that confidential or private or members only. There is nothing. It's a government website that somebody clicks open and it tells you how to send a message to that message board. And you send the message to that message board, and then the next thing you know, you got 8 FDLE agents at your home, even if you're not the one that sent it. If you're
Join the meeting.
Go ahead.
Okay. So there's, where does Mr. Pratt get off saying that it's, that these are the rules of the website? He doesn't make the rules of the website. He doesn't know anything about the Department of Health and its policies, or if he does, he had a duty to disclose what he knows and where he got it.
So, Mr. Johnson, who has the burden of proof in this motion? Do you have to prove that the affidavit, probable cause affidavit, is false, or does the FDLE have to prove that it's accurate?
They have to prove that it's adequate. They have to prove that it's sufficient. And that's where the burden lies. And they haven't met the burden.
Don't they have to prove that it's sufficient on its face? Because the judge who looks at a probable cause affidavit can only view it from the face of the affidavit. There are a line of cases in federal court that gives a cause of action for this. If a search warrant is intentionally false, an affidavit is falsified or knowingly false information is contained in it, but that's a matter of proof for later, isn't it?
Well, it's a matter of proof for here and now. In this hearing today, in front of you, and the material omissions are as important as an outright falsification. I think it might be an outright falsification that the access is restricted to people who are employed by Department of Health or some other agency, and that access goes away. If that were the case, that would be written somewhere. That would have been something that could have been produced. It could have been produced even after the fact, but it wouldn't have mattered if it was produced after the fact, because it wasn't produced to Judge Hawks. And the material omissions, we've got 2 paragraphs in our memorandum of law, which I'm sure you read.
I read it twice, maybe 3 times.
Yeah, and I know that's how you operate. If he failed to disclose that was on the website for anybody to put in the username and the password, Judge Hawks, if he had known that, probably wouldn't have issued the search warrant. And if he had disclosed the fact that there is nothing anywhere in any Department of Health policy that says this site is restricted, you can't use it. You just have to assume those things. They're saying that the user should be able to figure out that you're not allowed in here, even if nobody warns them. Yeah, that's really like saying, if you go into Publix without knocking on the door, we're going to arrest you for trespassing. Well, no, you assume that you go into Publix as an invitee and you don't have to knock on the door or get permission. That's what any reasonable person assumes. Any reasonable person who goes to a website and is given the username, the user ID, and the password to get in and finds nothing on there that tells you otherwise, that tells you to stay out or that it's members only, then that's an invitation. It's an invitation, Your Honor. That's what it is. And if there's and there's a material omission, nobody alerting Judge Hawks that the password and the username are given and that there is nothing telling anybody to stay out. If that had been in the affidavit, do you think any reasonable judge would have signed that warrant if they had made the full disclosure of all the things they should have disclosed? And there's one last thing.
Okay.
And that is the Craps case, State versus Craps. And what State versus Craps that we've discussed briefly in the memorandum says is that it's a archaic statute. It was written at an earlier time. And what it says is that there is no ban in this statute on accessing the software or the contents of anybody's computer, only against accessing a device. And
Is it a computer system?
yeah,
Is that solely
and what
limited
Craps
to the
says is that
device?
means a physical device.
Can you let me get to that case? Hold on a minute.
Yeah.
Give me the name of that case again. I think I have
State
it here.
versus Craps.
Hold on a second. I thought I copied every one of your cases you cited. Let me find it. Where
Okay.
is it in the in your memo?
It's right at the end of the no crime section, right before the probable cause section starts.
Hold on, I'll find it.
I've got a paragraph on it.
Okay, 180 Southern 3rd. Let's see, I think I have it. Just a second. 180 Southern 3rd. All right. Give me a second. Let me pull that up on Westlaw real quick.
Okay.
One, 125. Could you point out to me where you want me to read that case? Where in the case, what's the operable language that I need to look at?
Yeah, I think so. Let me get the memo.
I'm looking at the footnote, the head note 2 or keynote 2. The state must establish that defendant accessed one of the listed tangible devices without authorization.
Not the data and other information located on the device. Thus, to prove a violation of section 815.061A, the state must establish that the defendant accessed one of the listed tangible devices without authorization, not that the defendant accessed a program or information stored on the device without authorization. So here's what Rebekah Jones would have had to do. She would have had to get in her, they're saying she used her own computer from her own home. But in order, according to Craps, she would have had to get in her car, drive out to Southwood, go through security, wander around in the Department of Health building until she found an unattended computer, sit down at it, and send the message from there. That's what it would have taken for her to violate the statute in accordance with Craps. And that's the first DCA case. It's controlling authority in our jurisdiction. Now, there's a second district case in the interest of full disclosure called Umhofer, which says that there is a way that you can structure your affidavit to describe the manner in which it goes from the home computer to the office computer, and that Umhofer, the police in Umhofer, described that correctly, unlike the police in Craps who didn't. And the police in this case did the same thing that the police in Craps did. They did not link it to a device. They linked it to the contents of a device. So in that sense, the search warrant is again void ab initio.
Just a second here. I've got a question for you on this case. I want to look at something first. All right, wouldn't to access this device, wouldn't a person have to go on a state computer network to get to this program? Isn't this program on the network?
Yeah, but it's a physical network. And, so that's the point of Craps, is that you have to lay hands on their property, not lay hands on your home computer.
Okay, so I shepherdized Craps. You know that there's a case that explained Craps. It talked about Umhofer versus State, 235 Southern 3rd, 989.
I was just telling you about that.
Yeah, and here's the thing. It says here, the Umhofer case, in referring to Craps, says the court stated that to prove a violation, the state was required to establish that the defendant accessed one of the listed tangible devices without authorization, not that the defendant accessed a program of information stored on the device without authorization. In determining that the state failed to prove its case, the First District pointed out that it had before it no evidence to explain how accessing an Instagram account works from a technological advance, leaving unanswered whether or how appellant's actions amounted to accessing a specific computer system, or computer network. The court stated it did not foreclose the possibility that the state could present sufficient evidence to prove a violation of this 815.06 for unauthorized sexually explicit internet postings such as those in this case. Now, was the allegation, going back to the First District case, let me go back to that. The appellant was convicted of violating an injunction in unauthorized computer use. In the allegations were that he he logged into his girlfriend's Instagram account and posted certain photographs without her permission. Whether that constitutes a violation of 815.06. Is that different? The allegation here is that there was the state system was accessed on which a state computer program resided. Isn't that different from the allegations in this case? I'm not sure if the First District were experts on Instagram at that time or not. I wouldn't have been at that time.
No, what Umhofer is explaining is that it's how you structure the affidavit in support of the search warrant. Mm-hmm. If you establish that nexus between what the defendant did and the state's computer system, but if you are only establishing a nexus between information that's being transmitted between somebody's home device and somebody's government device or the girlfriend's device in the Kratz case, then you've fallen short. You've not established your nexus. There's a whole missing element in there that makes your search warrant void, and that's why the first DCA voided the search warrant in Kratz, and that's why the Omhofer court in the second DCA said that the police in that case didn't make the Kratz mistake. But the police in the Rebekah Jones case made exactly the Kratz mistake because they left out any nexus, any establishment between what she did and a device or a system. All they're talking about is the contents and the communication and the transmission. They made exactly the Kratz mistake.
What about the allegation that says the ReadyOp is a web-based platform development for, and then it lists what it's developed for?
Yeah, I don't think that,
Does that
I don't
describe
think-
a
I don't see
computer
how that
system
gets you there.
network?
I don't see how that gets you from Rebekah Jones' house to a state's physical device. You know, they never even mentioned a state's physical device.
Okay, I understand your argument.
So that's what I've got on the first half. The first half was that there's no crime. And because there's no crime, there can be no search warrant to search for evidence of a crime. The second aspect is the probable cause, that there could be no probable cause because you have to give the judge something way better than what the FDLE gave to Judge Hawks in this case. For one thing, he said that he connected Rebekah Jones' IP address to the unauthorized message that went out on the message board at the Department of Health. And he did it through, quote, investigative resources, end quote. The investigative resources, for all Judge Hawks knew, could have been a Ouija board, it could have been a tarot deck, it could have been the officer doing the great Carsoni thing, where Carsoni the Magnificent, where he puts his hand up.
It was Karnak the Magnificent.
Karnak the Magnificent, yeah. He put his forehead up to his hand and he would just divine these things. You don't just say, I used investigative resources. You got to say something about what they are. But even if he had done that, let me spot them that for just a minute, that he's an established clairvoyant and that his clairvoyance is admissible in evidence. The IP address is not enough of a nexus. And that's what all the established case law flowing from BitTorrent and the 2000 cases that have followed it have said, that the IP address is too general to connect to any specific individual. It's not like DNA or a fingerprint. Anybody could use that IP address simply by parking in front of her house and with a laptop, and you would be sending things from her address. You could be a neighbor, you could be a visitor in the home, you could be anything. You don't have enough of a nexus just by establishing an IP address to connect it to a person with sufficient certainty to go into their house and ransack the place and take their property and shut down their business. Now, this is a fairly serious thing because this is how Rebekah makes her living. First, DeSantis's team fires her from her job for being a whistleblower and refusing to falsify data. And so she sets up another way to make a living through the income that she makes from reporting the data that she used to report at the Department of Health, only doing it honestly and accuracy. And the next thing she knows, she's got the DeSantis team at her door shutting down that program the way they shut down the one that she was operating at the state. And they take her $12,000 computer that was specifically designed to do this stuff, and they're holding it. They're holding it in this limbo. They won't fish, they won't cut bait, they won't bring a criminal charge, and they won't turn the property back. And they could sit there holding that in this pattern until the computer becomes obsolete and worthless, and they will have in effect stolen $12,000 from her, plus the other computers and the cell phone. They're sitting on all her attorney-client communications. They're sitting on all her confidential sources of all the other whistleblowers that are collaborating with her to put this information out. And they won't crap, they won't get off the pot, and they're just going to sit there holding her thing. And they're not going to bring this case. Could you imagine somebody taking this case in front of a Tallahassee jury? Could you imagine trying to get Jack Campbell to file this charge? They can't do that. They would be destroyed. And so what they've got to do is simply keep the computer and keep the property away from her and never file a criminal charge where we can go in and contest it and defeat it. But they still keep the property and they still violate her constitutional rights by doing all of that stuff. Now, we put in the declaration of Bennett Cyphers from the Electronic Frontier Foundation, who is an
I have to
expert.
wrap it up because you've used up more than 30 minutes. I got to let Mr. talk. I've already ruled against Mr. Knox before he opened his mouth, so I need to let him talk some.
Okay, great. I'll just say one last thing then, and that is that if they had really wanted to know who sent the message to the DOH message board, they would have taken the router and the modem, which are the things that they could have taken to do that. But instead, they took what would give them the confidential sources of the other whistleblowers, leaving behind the router and the modem.
All right, thank you. I'm going to give the court reporter about a 5-minute break, and then we'll start back with Mr. Knox. I'll be right back. I'm going to leave the camera on. I'm going to walk outside, and I'll be back in 5 minutes or so.
Y'all enjoying the Florida weather?
It's
I
pretty
don't.
nice here.
It's so cold here.
You got all those crazies up there now.
The day after I move here, of course, there's the storming of the Capitol.
Yeah, they're going to storm the Capitol here too, but I wondered, what are they going to do? Are they going to take all the wing nuts from inside the Capitol and march them outside the Capitol and then they storm back in? Is that how that's going to work here?
I don't know, but there's like helicopters like all day, every day, and it's crazy.
15,000 troops up there, I heard.
What was that?
15,000 troops up there, I heard. Crazy.
Sorry, I've been having trouble with these headphones this whole time. I can't find my good ones though. They're in a box somewhere.
Packed in.
Still working on it. There's some boxes like behind me that are not packed. I'm trying to cover up. But
I got all kinds of boxes behind me.
Jake was really hoping for snow, but it's cold but no snow. But I said, it's kind of a trade-off because I insist on having sun and he insists on having cold. And so here we really have both. Because it's not too cloudy like it is in Syracuse, but it's not, hot like it is in Florida.
Yeah. So it's your dog's happy though.
Oh yes, she is. She won't even come inside. She's having a ball, and I have to like get the kids all new clothes because you can't just like put on a sweater and go outside. You need like pants that are like thick. Like I think my son only owns windbreakers for pants for some reason, and so we have to find him blue jeans, and he hates it. So it's an adjustment. Yep, those work. I believe Matthew Fart's last name is the device that's making the noise. It pops up every time I hear the noise. It says Matthew, last name starts with an A, is talking.
either do it, I can do it later or I can do it on the papers. Okay, is everybody back?
Yes,
Ms. Martin, are you there? Okay, great. Mr. Knox?
Yes, Your Honor, thank you. I understand that you have ruled against our argument on jurisdiction, but I just want to clarify, our argument's not arguing you don't have concurrent jurisdiction. Our argument is that inherent jurisdiction of this property is in the court of Judge Hawks. And this is the reason why section 911.14 refers to if it appears to the judge before whom the warrant is returned that the property or papers taken are not the same as that described in the warrant, or that there is no probable cause for believing the existence of the grounds upon which the warrant was issued, which is the main argument here.
Mr. Knox, I have a case from the 3rd District, 1981, that's not reversed that I know of, that says it is clear that any circuit judge would have jurisdiction under 933.14 to entertain a motion to return the property. That's about as directly on point as I've seen in a while.
Yes, Your Honor, but the key thing here is in order for a sufficient on its face motion for return of the property, and I'm referring to Bolden versus State, 875 Southern 2nd, 780. This is under head notes 1, 2, 3, and 4. It says to be facially sufficient, the motion must allege that the property at issue was his personal property, was not the fruit of criminal activity, and was not being held as evidence. There is no allegation in the current motion that the property is not being held for evidence. But let me go on.
well, that's wrong.
Is Bolden the case brought pursuant to 933.14? Because
Yes,
it is. Hold on a second. Let me find it. Is that 1st District case, Bolden?
Nope. No, sir, it's a 2nd District.
Okay, there's a 1st District case on that point too. Let me find Bolden. Here it is. All right, what are you reading from again?
I'm reading under head notes 1, 2, 3, 4.
Yeah.
And if you go about halfway down, it says first, the defendant must file a facially sufficient motion for the return of property.
Mm-hmm.
Cites Brown, and it says to be facially sufficient, the motion must allege that the property at issue was his personal property, was not the fruit of criminal activity, and was not being held as evidence.
The motion says on page 3.
The reason I'm asking you this question is the Kuhn versus State case was not brought under 933.14 that was cited. Judge Dempsey wrote that case. No, I take that back. She wrote a case in 2000 something. This was written by someone else. There is a case that Judge Dempsey wrote that's not too far off from that. I'm looking at Bolden to see if it's brought pursuant to 933. See, here's the problem. Let me see if I can find this other case.
Your Honor, I think we could short circuit this because page 3 of our motion says exactly what he says it doesn't say. Right in the first paragraph,
Okay.
word for word.
Let me boil this down. I don't have a cite from anybody, the case site that I am aware of that helps me with this point. My belief is that the standard in this case is that when I'm determining probable cause, I look at this as if I were the original judge to determine whether on the face of the probable cause warrant, is there probable cause to issue a search warrant?
Right.
Under that standard, then I'm entitled to rely upon the facts stated in that affidavit since it's under oath as being accurate. I also understand the law is that those facts do not have to be in the form of admissible evidence. Is in, as the statute says, hold on, let me find 114. The statute says 913, is there no probable cause for believing the existence of the grounds? I don't have any evidence that those grounds were false at this point, as a judge never does when they're looking at a search warrant. Normally, you would test that in a motion to suppress. For example, going to the point that there's not a requirement that all the evidence in an affidavit be admissible, it's often the case where confidential informants are used to support probable cause affidavits. There has to be some statement specifically with respect to a confidential informant to show they're reliable, but usually that can be conclusory, like I've used this person several times before and have always been accurate. The issue here is the presumption to me is that these facts are accurate as stated. The burden to show that they are either not accurate intentionally or otherwise, and that they're material such that it would cause a reasonable judge to change the finding, that's on the, in this case, Mr. Johnson's client. Normally, if there was a criminal case filed, you'd be hashing this out on a motion to suppress the evidence before the judge who was assigned the case. The issue here, if I look at all these cases, first of all, most of these cases arise when there's been a search warrant in a trial in which evidence has been used, but not all the evidence that was seized under the search warrant. So the issue is there going to be a second charge using this evidence, or do they return the evidence? That's what I see in a number of these cases. And basically, the test, here's one case. Oleandy versus State, 731 Southern 2nd 4. And it says, the state would be required if it wished to retain the items. This is a case where there's been one trial already, but following charges haven't been brought. If it wished to retain the items, to timely file forfeiture proceedings, that doesn't apply here, or make a showing that it intended in good faith to bring another criminal prosecution for which items would be admissible. There's another issue which has not been discussed by either side. And let me find my note. That's the separation of powers argument. At some point, to start analyzing that argument, it's very clear under Florida law in case decisions made that a court does not have authority to tell a prosecutor, in this case, a state attorney or a statewide prosecutor, that what charge to bring, when to bring the charge, whether to prosecute a charge, whether or not to prosecute a charge. That is considered classic separation of powers. I don't have that case, but if you need it, you can look at one of my opinions that I've written recently. I'm trying to think. I can find it if you need it, but there is a district court case that says that. There are also district court cases that say, for example, it violates the separation of powers for a circuit judge to tell the sheriff how to run the jail. The separation of powers doctrine before this Florida Supreme Court, in particular in the First District, are very strongly enforced. This case, this search is a little over 2 months old. What I'm being asked to do is in about 2 months, maybe 2 months and a couple of days, is tell the investigating agency they have to stop investigating if I agree with Mr. Johnson, and they have to return all the evidence. I'm not sure, and I've not seen this addressed by either side, that I've got the authority to do that. Now, the statute 933-14 gives some help to it, but it doesn't provide a precise outline. In other words, there's no precise gate on where the boundaries of this property is, in the sense of if you have a property line dispute. I don't have a fence. I do know, if you go to extremes, that if you asked me the day after this, I would say it's too soon. If you waited until the statute of limitations had run and Mr. Johnson was here and the statute had run, I'd say there's no way the state can prosecute on this. They have to return the evidence. The rub comes when it's 2 months out. No one's yet told me what the statute of limitations is in this case. Let me see if I can find it real quick. Third-degree felony. I'm thinking it's probably 2 years, but I haven't looked that up. It's not been cited to me in any memo. But we're 2 months out. I don't have any statement from the defendants. Do they intend, Mr. Knox, to bring up a charge based on this, or what? What are their intentions?
Well, Judge, that's my point. My client, Rick Swearingen, as commissioner of FDLE, doesn't make that decision. That's a decision that's made by the state attorney's office as to whether to bring charges or prosecute or not. And that's what I was arguing. My argument was under Bolden v. State was the state needs an opportunity to respond as to whether or not this property is or is not going to be used in a prosecution.
Well, are you saying that the state attorney, Mr. Campbell, is an indispensable party?
Well, he's certainly the person that's of interest here with your ruling as to whether to return the property or not. FDLE can't do anything with the property other than investigate it as it's doing right now. It can't make the decision that Ms. Jones should or should not be arrested.
All right,
my argument is saying that's why the inherent jurisdiction of Judge Wheeler, of Judge Hawks' court, is the one that needs to be deciding this, because the state attorney would be present there to make an argument if it was opposed to such a motion.
He'd be present here if y'all would ask him to come, either side. I have not given that argument any consideration, whether the state attorney is an indispensable party in this case. I can't tell Mr. Campbell whether to bring a charge or not bring a charge. I just need to know, does he intend to pursue this? If he says, Mr. Knox, that he does not intend to bring a charge, that gives one result. If he says it's too early for him to tell, that might give a different result.
Well,
So,
Your Honor, doesn't
Mr.
I think
Johnson, what do you say?
the ball's in FDLE's court, not Jack Campbell's court. They have the decision to arrest her or not arrest her. That's what FDLE does. That's a police decision. It's not a prosecutor's decision, although it could be a prosecutor's decision. But it's a police decision, and they made this whole case.
Isn't it, don't the cases say that there must be a showing on good faith and intent to bring another criminal prosecution? Doesn't the state attorney bring the criminal prosecution, not the FDLE?
Yes, sir.
There has to be an arrest before there's a prosecution. And the police make the arrest. And the police make the decision to make the arrest.
If there is an arrest and there's no information filed and no indictment issued from a grand jury, then there's no criminal prosecution.
No, there isn't a criminal prosecution, and that's why I keep wondering. They say bring it to Judge Hawks. Judge Hawks is not even on the criminal bench. He's on the family bench. He just happened to be the duty judge. There's no case number. There's no docket. There's no possible way to bring it before Judge Hawks. It's a catch-22. They're saying bring it before Judge Hawks, but
That's why I say you're right on that point, Mr. Johnson. I'm not saying they should bring it before Judge Hawks. I don't think the law requires that. I think it's in my lap right now, unless and until an information is filed of some sort. If
Well,
an
right,
information is
but-
filed, then jurisdiction transfers. The jurisdiction transfers over to the criminal court.
Well, and there's constitutional issues here, though, that, in my view, trump everything else. The woman's got to make a living, and this is the means of her support, and it's her First Amendment right to use that stuff to put out the information that she puts out. And they shut her down, and they want to keep her from communicating what she's communicating, and they do that by bringing a frivolous allegation, not being willing to make an arrest and take the consequences of the arrest, not bringing a prosecution and being willing to take the prosecution, but holding it in limbo and holding her property in abeyance until the property becomes obsolete and $12,000 is lost down the drain, and it's punishment for free speech. That's all that it is. And there's got to be a point of entry to challenge that. And there's got to be a way to make them come forward and say something about what they're doing with it. If they're conducting a criminal investigation, they ought to come here and say that. They didn't come here and say that. FDLE has got 2 lawyers here, and neither of them is saying we need to keep this for another month. We need to keep this for another week. We need to keep this. Here's how far along we've got with determining whether we think there's a crime committed that we're going to recommend to Jack Campbell that he bring a charge. They're just going to sit on this and hold it because they don't want the publicity. They've got a tiger by the tail. They made a stupid decision to go issue this search warrant and take all this stuff, and now they can't find a way out of it. The only way they can find out of it is to hold on to the computer equipment forever until everything blows over. There's got to be a point of entry where a citizen whose constitutional rights are being trampled can come before a judge and have something done. I think that what you need to do is ask them where they are and what they're doing with this stuff. And they got 2 lawyers here, and they can tell you, they can do it today.
Well, Mr. Johnson, I'm doing my best. As you know, I'm not a criminal judge either, although I have 12 years ago, I was a criminal judge for 2 years. I do read, try to read just about every decision the First District and the Florida Supreme Court issue. So here's my conclusion. I don't think the warrant as it is, the probable cause affidavit it is written, I think states probable cause in the sense that I don't see any basis that a judge would change this from reading the warrant. I think it states sufficient probable cause to investigate a potential violation of this statute. There's not been an information brought under this statute. I think the argument with the First District case would be an argument to make on again, I think it's called a motion to dismiss in criminal, but a motion in criminal, I think it's a motion to dismiss that they use in criminal, or a motion to suppress, which is used. But here, I think it meets the elements of the statute sufficiently for probable cause. The probable cause determination for a search warrant is lower than the determination it would take to survive a motion to dismiss or a summary judgment. The burden shifts from the search warrant to the defendant to show that there's a material misstatement or a material omission that is so significant that it would result in any reasonable judge coming to a different conclusion. That's the Franks case, which you've cited in your memo, which is used in federal court all the time. When I was a lawyer, I handled a couple of those cases, and it's the Franks is a U.S. Supreme Court decision, as I recall. I believe it's U.S. Supreme Court decision.
It is. Yeah.
And it requires not just a material omission. It requires more than just an omission or a misstatement. It has to be material that as such, it would have changed the result of the issuing of the warrant or not. I have not seen anything today that says that that's the case. I also have not heard from the defendant that say that they, whether it be the state or from the prosecutor, that there is a good faith intent to bring a criminal prosecution at which the items would be admissible in evidence. Therefore, I don't think I can give a full ruling today. I can at this point not grant the relief, but I think I'm going to have to continue the hearing. So I think the defendants have got to tell me whether or not it's going to be used. Now, I don't think they have to know exactly what they're going to do with it 2 months out. But if they have decided that they are not going to bring criminal charges, I need to know that. Or recommend to the state attorney that criminal charges be brought. I think I need to know what the state attorney intends to do and what the FDLE intends to recommend to the state attorney. And for that reason, I'm inclined to think the state attorney is an indispensable party in this case. So I guess what I'm doing is not ruling. I'm not granting, Mr. Johnson, I'm not granting you relief, but I'm not denying the relief because I think the record in front of me is not complete.
What do I need to do?
I think you probably should add the indispensable party.
Okay. I'll do that.
Or the parties could ask the state attorney if the state attorney will provide whatever information it can under the standard in these cases. I don't want to speak for Mr. Campbell. What I am not going to do is tell Mr. Campbell what he has to do, whether he charges or doesn't charge. If he tells me that 2 months out, there's not enough time, that he's still investigating the case, I think at that point under separation of powers, I would be reversed if I made him return his evidence this early into the case. That's where the line drawing comes, Mr. Johnson, and I don't have really any clear standard from any appellate decision I've seen that tells me where that line is. If the statute had run, I'd have a line there, but that hasn't happened.
Right.
So I need to know from I'll cite you the case. There's more than one case that says this. Bolden, which we've all talked about, 2nd District case, and it says, the defendant is not entitled to have the property returned if the state intends in good faith to bring another criminal prosecution. You have to remember Bolden was one of those cases where they had a first charge. That case was done. They still had some evidence that was not used in the first charge. Are they going to use that evidence in a second charge? It's not exactly the same as here, but it's similar. I just don't think the state can keep evidence when it has already made a decision it's not going to use it. If it's investigating that and can't determine it, I think the state's entitled under separation of powers to have a reasonable amount of time to make that decision. But I think Mr. Campbell might be the only one who can make that decision at this point. The FDLE can make a suggestion to him, but the only other basis for bringing a criminal charge, Mr. Johnson, would be the statewide prosecutor, and I'm not sure this is the type of case a statewide prosecutor would take. That is an area on which my expertise is limited and my briefing is zero. So I'm going to not grant the relief at this point, but I'm going to keep the motion open for further consideration. Also, I think Mr. Johnson recognized that this is a potential removable case to federal court since it's a 1983 action. Mr. Johnson and I are kind of old hands at federal court 1983 cases. So I immediately recognized it as he in good faith recognized it. So Mr. Knox, I don't know whether the time is run to remove it or not, but if you're going to remove it, you might as well do it so the federal judge can resolve these issues instead of me. I think it's in everybody's interest to get this motion ruled on as quickly as possible. And I'm not delaying, but I think under these cases, I've got to have some indication, has the state made a decision to not pursue criminal charges? If they have, I need to know that. If they haven't, I need to know that.
What do they know today?
Mr. Knox, Mr. Knox, my guess is you don't know what that decision is today.
No, that's correct, Your Honor.
Okay, that's why I'm not granting and I'm not denying. I'm keeping this motion open. I'm deferring ruling on this motion pending finding out whether there is any intent, whether there's been a decision made to either one, we're not filing criminal charges, or two, we might be, or we are going to. And if it is we might be, I'm assuming that would be based upon a good faith intention to continue investigating and then to make a decision at some point in the future. The whole issue of separation of powers, I get very close to that line when I start trying to tell Mr. Campbell when he's got to decide whether he's going to bring a charge or not. I don't think I can tell him that. So there's some tension between constitutional separation of powers, Mr. Johnson, and this statute. And I don't see that resolved in any case. It may be this case the first district would want to resolve it in, but I don't see a case where that issue's been addressed by anybody. But I do know, reading first district opinions every week, that that's a vitally important issue that they address in cases of this type, usually. So I guess it's a draw at this point. Undecided. I will say this, Mr. Johnson. I do not agree that there's no probable cause shown on the face of the affidavit. And I do not believe that the decision made by the prior judge was in error. Whether or not there was a false statement given or a false material omission involved in this is going to have to be subject to another hearing on another day, because I can't make that determination today. So I would ask that you and Mr. Knox maybe get together and decide how you all want to proceed after Mr. Knox has a chance to talk to his client. Whether or not you want to include the state attorney in or not may depend upon perhaps Mr. Johnson and Mr. Knox asking Mr. Campbell for a discussion on that issue. I'm not saying you have to sue him, but in some way you have to know, are they investigating it or are they not investigating it? If he says I'm investigating and I don't know, I don't think at this point this early, Mr. Johnson, that I can grant the motion. But Mr. Knox, if he's saying I've looked at it and I don't think I'm going to bring a charge, then we all need to know that.
Well, there's one other thing, Your Honor, and that would be that if they say they're investigating it, but there are some parts of the equipment they have that could be of no possible use in that investigation, could we not order that they return that and keep whatever it is that they need to do the investigation.
If the proper authority told me they don't need everything they have, and there's some parts of it they don't need, I would think you all could probably do that by agreement. And Mr. Knox and with the state attorney in the FDLE, you could probably do that by agreement. But if there are pieces of these items they don't need, then I don't see why they would need to keep it if they don't need it. So that's the best I can tell you there.
Okay.
Thank you, Your Honor.
I would say, Mr. Johnson, you wrote a good brief. You and your co-counsel, I'm sure, who were involved in it. Mr. Knox, your brief was very informative also. I'm sorry that I have not made a decision here, but sometimes when you don't have all the information, it's probably better to defer and get all the information and then decide. But if you are going to keep it in state court, that's something that everyone needs to know. If you think it's going to be removed to federal court, that is also a fact everyone needs to know. So there's kind of two unknowns, Mr. Knox. What's going to be done vis-a-vis criminal charges and what's going to be done vis-a-vis what venue this case is going to be in.
Understood, Your Honor.
If it's in state court, Mr. Johnson, I still have my old copy of Nahmud's 1983 text. I don't know if you ever used that in your practice or not.
Yes, I did.
I'm told it's multi-volumes now instead of the one volume I used to use, but I do have that. So I'm ready if it stays in state court.
Okay.
All right.
Judy,
I don't know
we'll
how
take
you're
it.
going to draw something up. You can just say, for the reasons stated on the record, I defer ruling on the motion. I have found that based upon the affidavit that it does state probable cause on its face, but that still leaves open the Franks issue that Mr. Johnson could bring up at a later date if he wishes to. And then I'll wait to hear from you all as what you want to do. If you all want to do a telephone case management conference on pretty short notice, let me know and I can do that. Just if you want to let me know what's going on or when you want to get another hearing set or those sorts of things. If there's a telephone case management conference, you probably ought to make it a Zoom telephone conference. So if the media wishes to have access to it, they can, because it is even though because of our current pandemic situation, we're not open like we usually are. All court proceedings are still open to the public. So that's where we go. Thank you. I'm sorry for taking this long, but it merited the extra time to put on it. I didn't want to rush either side, and we've taken at least a partial step forward, and we'll see where we go.
Thank you, Your Honor.
Okay.
Judy, we'll
thank
take
you.
a copy.
Okay. Bye-bye, everybody.
Bye-bye.
Bye.
Judy, this is Craig Knox.